Hello, and welcome to Legaleaze, Please. I am your host, your creator and curator, and Professor Natasha Robinson. I am here on our digital platform, Legaleaze, Please. It is a platform that is designed to decode, demystify, and deconstruct legal language. In short, we build you up by breaking it down, it being any barrier, blockage, boundaries of oppression that seek to prevent your knowledge of information, comprehension about information, or access to information. And so I'm glad that you are here, whether you are with me live or whether you are watching later. Please indicate in the comments that you are here. You can also click like and share. I started a series called Freestyle Fridays or Freedom Fridays, where I, as a legal practitioner, that I would be sharing with you and teaching to you, the community, as part of my communal offering, different tactics, different information about laws, about strategies, and about policies that can affect your everyday life in ways that you may not initially believe that they affect your everyday life. And so I am here today because I am going to be talking about making objections in law and in real life. Making objections in law and in real life. Did you know that in the courtroom, whether it is civil, which is whether or not someone is financially liable and should have to pay or not pay for a legal responsibility, legal harm or injury that they committed, or in criminal court, where the issue is whether a person should be held accountable by way of a conviction, or is there not enough evidence to prove that, in fact, they are criminally responsible? In either of those courtrooms, that there are what is called objections. Objections are usually spoken, they are articulated, where they are being said to a judge, I, as the attorney, wish for this information, this evidence not to be considered by a judge or by a jury, which, depending upon which state you're in, can be 6 people or it can be 12 people, any range in between there. And so when the objection is made, there is a determination by the judge, who is the fact finder, who is the listener, and the judge will determine whether or not the objection is being sustained, meaning the judge agrees with the person making the objection, or the objection is overruled, which means that the judge does not agree with the person making the objection, and that the evidence by way of physical, tactile, whatever you touch, or what is testifying to, that line of questioning regarding that can be considered. Okay, so to say again, an objection is usually a verbal, spoken indication that the attorney wishes not to have that information come into evidence. Usually an objection is made by the opposing counsel to whom the questioning is made. For example, if a prosecutor is questioning a witness and there is something that the witness is going to testify to or use in their testimony, the opposing attorney, which is the defense attorney, can make an objection. That objection can say, Judge, we are stating that for whatever reasons, which the defense attorney may or may not state out loud, we do not want for this evidence to come in, either because it's prejudicial, because it doesn't matter what's happening, because it has nothing to do with whether or not there is a finding of guilty or innocence of the defendant, which would be their client. Okay, so the objections, they can just be stated very clearly, objection, and there is no explanation, or they can be what's called an objection, a speaking objection, which is where the attorney will give the reason for why they are objecting. Usually in jury trials that I have done, whether they have been from regular battery all the way up to first-degree murder, when I was with the law office of the Cook County Public Defender, what I would have happen is for jury trials, the judge will make very clear not to give speaking objections where the attorneys are not giving reasons for why the evidence is being objected to, but rather we can do that to the side out of the presence of the jury. And there is a court reporter that is usually there that is taking down the information that we are objecting to. So we're still on the record. We're just not in the presence of the jury. But for bench trials, which is where a judge makes a decision as to the guilt or the innocence of the defendant, the judge is able to separate out what is needed to make a decision. And there usually is not a off the record conversation unless it is something that is so egregious or harmful. Okay, so those are what objections are. Objections are made in court and they are made in real time. So when you are listening to evidence, you do not wait until the question has been asked. At least this is how I teach it, is you do not wait until the question is asked, and you definitely do not wait until the questioning, all of the questions, has been finished, because there may be something that may come out that may be hurtful to the side that you're on. In my case, for criminal, it's prosecution, which are the attorneys that are bringing the criminal allegations against the defendant. And then you have the defense, where I was, where you are representing the accused. You don't wait until there is the fullness of time for your side. Rather, you make an objection, and you make an objection there. And also understand that you are thinking ahead of time. So if there is an issue which you wish to raise on appeal, most times you waive or you surrender that right to make an objection in the appeal if you don't make it in real time in the trial court. Okay, so those are just some things that you need to consider. If you are coming in, welcome. Please click like and share, because we are going to learn about making objections in law and making objections in real life. So the second thing I want you to know is that when you are watching your favorite shows like a Law and Order SVU, a Law and Order Criminal Intent, the First 48, whatever it is, I want you to understand that there is a level of entertainment that is supposed to occur. I was talking to a student earlier, and a student was interviewing me, and I was telling her, she said she wanted to be a forensic psychologist because of shows like Criminal Minds. And so, you know, part of my apprenticeship, if you will, my mentoring is letting her know that in Criminal Minds, they're always going to catch the person, the serial killer, the sociopath, the psychopath, because one, it's scripted that way. And then two, what type of show would it be if the guilty would always get away? So, and then I went to tell her about in court scenes or in court movies where there are objections, it does not always go the way it happens in real life. And that is because sometimes if it happens in real life in a movie, there would be no need for entertainment. And so you have to spice it up a little bit. You have to make it a little, entertaining. But understand that there are rules and there are ways and there are procedures that happen in real life that do not happen in entertainment. So just be careful about that. What you see on TV is not always how it happens in real life. I just want you to be clear about that. Okay. Let me stop and say hello to everybody. Hey, Mama Hazel, how you doing? Hey, Sora, Pastor Verzola. Yes, it is not real life. It is entertainment. And the sooner we can separate our expectations from entertainment, the better off we will be. All right. So let's get into it. So we're talking about making objections in law in real life. And of course, who would I be without showing you the real stuff? So this book is called Cleary and Graham's Handbook of Illinois Evidence. Illinois Evidence. And so this is my actual law book that I had when I graduated. And hold on to your hats. I graduated in May 1999. Yes, that wasn't even this millennia. So for anyone who's watching, it's like you didn't even graduate in the 21st century. You are right. However, the 20th century was just not too long ago. But this is my book. Okay. You see, I write my name on my books because I am a person who treats my books like I treat children. I love them. Okay. And so this is my actual book. I checked this morning and I think they are on the 9th edition. And what I have is the 8th edition. What does that let you know? It lets you know that I am almost 24 years in the game as a licensed legal practitioner. And what it also lets you know is that the time in between editions can take decades. They can take decades. Okay. So I brought that so that you are able to see that this is the textbook that I used when I took the evidence class in my law school. Where did I go? University of Wisconsin. When did I go? Google it. Okay. All right. So this is the book. And if you open this book, you will see, because I like to write. I like to write and I like to highlight. Because when I was in law school, it was a very difficult experience for me. And it was not because I didn't understand what's going on, but it had more to do with self-esteem issues. But in any event, I'll talk about that later. This is the book that I'm going to be referring to. And if you really want to know all of the details in specifics, then what you do is you can order your own book, which when I checked this morning was $600 and something. Or you can go to law school, which is a little more than $600 some, or you can just listen to me. Okay, so I have already gone to law school for you. So I'm just going to highlight three objections that I want you to know. There are many, 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 many objections that can be made in court. And the way we learn them, at least the way I learned them, is in three ways. First, in my evidence class, which was in, I believe, my second year of law school. The second way I learned it was through my trial advocacy class, which taught you how to do a trial, how to represent someone who is charged with a crime. How do you speak on behalf of that person or those persons who they say they have been victimized by this person, and everything in between. That's the second way I learned. And then the third way I learned is baptism by fire, which is actually doing trials. And like I said, I spent 12 and a half years with the law office of the Cook County Public Defender, where I was an assistant public defender. I started doing misdemeanor representations. Those are the crimes for which anyone could be punished up to 364 days in jail or less. And then I went on to represent those who were charged with felonies, which can be anything from possession of cocaine all the way up to first-degree murder and everything in between. And so did that for 12 and a half years. So in doing trials, bench trials in front of judges, in doing trials in front of juries, this is how I began to own my craft, own my skills. Okay. And at the same time, I was of the original belief that unless you went to law school, you should know all of these specifics and all of these mechanics. And as I got a little older and got a little wiser, it came to me as people were talking to me that there has to be a space to understand what impacts you the most. And in law, when you think about it, most people are not impacted by the law unless it is times of chaos or times of crises. Okay. If you're in the church, think time of trouble. That is where you would be thinking about the law. And particularly law, when you're thinking about going to court or having a legal case, it involves there being some type of crisis or chaos. Sometimes it can be proactive, but most times it's reactive. Someone has been in trouble. And so I thought that in founding Legaleaze, please, not only can I present to you the legal terms, but I can explain it to you in everyday terms. And in everyday terms that does not provide shame, that does not provide guilt, because who wants to learn under those type of conditions? That it does not provide a level of pressure, where in fact you are able to learn, and not only learn, but here at Legaleaze, please, we believe in lifelong learning and lifelong sharing, where you are also a student as well as a teacher. And so I'm presenting this information to you so you don't have to get a case, that you don't have to be involved in a case, that you do not have to go to law school, but I can give you a very basic, a very comprehensive understanding about some things. And then you go to law school, and then you seek out a lawyer if that's what you want to do. So if you have not already, click like and share because I'm getting ready to get into the teaching. So the first objection, I said there were three. The first objection is foundation. The first objection is foundation. What happens with foundation usually occurs by this way. Say you have someone who is questioning the witness and they say, I'm showing you what is marked as prosecution's exhibit A. Can you tell me what this is? And the witness says yes. And so the prosecutor says, what is this? And the witness says, this is a picture of the scene that I saw at the time in question. And so then the attorney says, okay, Your Honor, I would like to take off Exhibit A's markers and I would like to move this into evidence. And then the defense says, objection. Now, the reason why defense says objection is for this reason, foundation. Whenever there is any type of evidence that is testified to or that is entered in physically, there has to be a foundation that is laid. Now, here's the official definition of foundation per the rules of evidence book, the textbook that I just showed you that has 950 pages. Okay, foundation. Has the qualifications of the witness been verified and or has the authenticity of the evidence been established? That is my synthesis of what it really said. Is I tried to take it and put it into everyday language. Has the qualifications of the witness, the person testifying, have they been verified, vetted, and or has the authenticity of the evidence, what you can touch, has that been established? Okay, so in short, what you need to know, if I were to sit in a conversation, you'd be like, Natasha, what is foundation objection? I would say, basically what I'm saying when I object is it is what it say it is, and they are who they say they are. Okay, that's everyday language. Is we don't know them. Is what it is, or are they who they say they are? How do we do this? We do this because the foundation of evidence is very, very, very key, because you do not want to rely upon something and the foundation has not been secured. So think about if you are buying a house, or if you are in a building, or even if you check your chair that you're sitting in right now, if you're sitting in a chair or any other type of apparatus, no one, or I won't say no one because it's a generalization, I will say hardly anyone will inspect the chair or inspect what it is that they are sitting on, because they have the expectation that it will do what it's supposed to do, which is to sustain the weight of the person sitting in it. Likewise, if you have ever gotten on an elevator, very few people will go to the side of the elevator where it has all the certifications and the certificate and the license to verify if, in fact, that elevator has been examined. And if it has been examined, who examined it? Are they qualified to examine it? When did they examine it? What did they find out to be? That is all foundation. Okay. And so when we're talking about the objection of foundation, we're saying before we rely on something, we got to check to see if it is what it says it is, or is the person testifying and they are who they say they are. If you do not lay the foundation, here is the strategy way for laying a foundation. Think of the questions that when you were in class, composition, English, French, whatever language, they always ask, what is the who, what, when, where, why, and how? Those are the questions that you ask when you're trying to lay a foundation. So the questions would be like, okay, who took this picture? When was this picture taken? Was there anything that was blocking your view with the view of the scene? Once this picture was taken, who kept this picture? How was this picture kept? Was it kept in a chain of custody or command? If so, who was the person who kept this picture? And is there anything in this picture that is different than what you are testifying to today? These are some of the things that will help lay the foundation. Okay. Because if you don't have a strong foundation, then what ends up happening is that everything that is built on top of that foundation slants a little bit. It's leaning a little bit. You're not able to rely on it. You have to lay the foundation, and you have to do it in such a way that not only is a person who listening to you that makes a decision as to whether or not a person is guilty, not only do they get to hear that I can rely on this, but if there is an appeal, then the persons who are making a higher decision, they are able to come in and say, we believe this evidence should be relied upon because the foundation was laid. Okay, so foundation, that's an objection, which is to say that this person who is using this evidence did not establish, is it what it says it is? And they have not established in the testimony of the person, are they who they say they are? Okay, that is the first objection. The second objection is relevance. Relevance is when, let's say, for example, the defense attorney is asking their client, can you tell me your name? My name is Natasha Robinson. And where do you live? I live in Cook County, Illinois. How long have you lived there? I lived there for about 20 something years. Can you tell us some of your hobbies? Well, yes, I love to go traveling, skiing, snorkeling, swimming. I like to dance. My favorite dance is a tango. And then the prosecution says, objection, Your Honor, relevance. Meaning, this might be nice to know, but what has this got to do with whether or not Natasha committed the crime for which she is being tried? Okay, so in the evidence book, again, I'm synthesizing. Does this item of evidence, physical, what you can touch, or testimonial, what is being said, does it tend to prove the matter sought to be proved? So in my example, when I tell you about all of my habits and all of my things that I like to do, my hobbies, the prosecution is saying, what has that got to do with whether or not a person is guilty or not guilty? Okay. Now understand, with objections, you can make them. Most, if not all, judges will give the side that did not make an objection a chance to explain. Why are you asking that question? What is your response to the objection? Now, some judges, not all, some judges will say you don't get a chance because you just got to either listen to my answer. So if the judge says sustained, that means that they're agreeing with the person who made the objection. And now, person asking the questions, you got to rephrase, meaning I agree with the fact that it ain't relevant. You didn't set the foundation. So either move along, counsel, or rephrase the question. Okay. And so if the judge says that I don't agree with the objection, the judge will say overrule, which is code for those who are asking the questions, you can continue. Okay, because we'll see where this is going. All right. So relevance is, does this item, the physical thing you can touch, or the testimony that is being given, does it prove the matter that the is at issue? Meaning, does it have something to do with this particular case? Or in short, remember I told you I synthesize it, everyday language. What they got to do with this? What they got to do with this? Okay, so when you hear a objection of relevance, then what the attorneys are saying without saying is what they're talking about or what they're testifying to ain't got a doggone thing to do with whether or not a person is guilty, whether or not a witness saw what they saw or they heard what they heard. In short, stay in the pocket. Don't get all out here and start talking about stuff that has no meaning or does not matter. Stay in the pocket. What are you talking about, and how does this push the issue of whether or not a person is to be found guilty or to be found not guilty? Okay, That is objection number 2. So remember, objection number 1 is foundation, meaning the who, what, when, where, why, and how of the testimony or the physical evidence. How do we know we can rely on this? How do we know we can believe on this? You have to be very specific. The second objection is relevance. What they got to do with this? Okay. If I ask you, what is the date today? And you tell me that the time is 1:37. Objection, relevance. What the time got to do with the date? Okay. And then the last objection is hearsay. Now, out of all the topics and evidence, out of all the objections, this is the one that for me is the most complicated. Okay. Because I know what hearsay meant in my culture. I know what hearsay meant in the street, but hearsay in law is something completely different. Okay. It ain't I heard it through the grapevine. Oh, I heard it through the grapevine. That is hearsay. Okay. When someone is talking to someone, person 1 is talking to person 2, and then person 2 takes it and goes to person 16 and said, well, I heard. That is hearsay on the street. In law, it's a little bit more complicated. In law, what happens? Oh, excuse me. What happens is the question becomes, is the out of court statement offered in court to prove the out of court statement is true? I'll say that again. In law, hearsay is what is said out of court. If you take that statement out of court and you offer it in court, are you trying to say that something should be believed because of what was said outside? So, for example, let me think of something. Let's say, for example, okay, I got one. So for some of us, we have watched Father's Day, which is the documentary of a gospel singer who is, while recording a soon to be released CD, they get information, word on the street, that the father who they think they have is not their real father. And so while simultaneously this gospel artist is recording their soon to be released album, they go on a journey to find out if their dad, who they believe was their dad, is in fact their dad. So what ended up happening is that the gospel artist ended up taking paternity tests by way of a DNA swab. And then the person that they heard was their father also took that test. They took it twice. And they found out in both tests that the person who the gospel artist believed to be their father biologically was excluded. It was this man who lived down the street and around the corner from the gospel artist's home. So for the purposes of court, if they're in paternity court and the gospel artist is testifying and says, this man owes me money because of the fact that he was supposed to be taking care of me as a child. And so the attorney goes on to say, well, how did you find out that this person is your father? And then the gospel artist says, well, I heard on the street, or I heard that he was saying that he might be my father. And the opposing counsel says, objection. Their objection would be hearsay, because the gospel artist is trying to take what they heard outside of court and offer it in legal terms. What is called is offer it for the truth of the matter or assert it, end quote, which means I'm trying to take an outside statement, use it in court statement, and use it in a way to say it must be true, because if I heard it outside, I could use it for the inside. Okay, so in everyday language, the question becomes, for a hearsay objection, does outside talk count for inside check? Okay, does what you hear on the outside, can it count for the inside? And not only can it count for the inside, what I mean is it the truth? So if it's said outside on the street where there is nobody listening, can you then offer it in court to say it must be true? Now, this is where hearsay gets complicated, because hearsay then becomes, there are certain exceptions to hearsay. There's always an exception. And one exception is what is called a dying declaration. So, say, for example, the gospel artist finally meets up with the person who he now knows is his, who he knows may possibly be his father. And his alleged dad, is about to have a heart attack. And as he is dying, he says to the gospel artist, I am your son. I am your father. Okay, that is a dying declaration that the gospel artist could use to say, look, this person who is dying would not have said it in their last final moments in this earth unless it was true. In the same way, for criminal court, if there is a person who has been shot, and if they are dying or succumbing to their injuries, and the police ask that person who shot you, and the person before they die, they say it was Joe Schmo. What that evidence is that statement can be used in court to say it really was Joe Schmo who shot this person, because why would this person lie as they are facing death? Okay, what I want you to know is that even though it is offered as the truth, it is not offered as unadulterated truth, which means that the opposing counsel can still ask questions about that statement. They may not be able to ask a person who is dying or has died, but they can attack what is called the weight or the believability of that statement and say, just because it's said does not automatically mean that it is true. Okay, so that is hearsay. Yes, divine commander, there's always an exception. Always, always, always. Okay, so those are the three objections. Let's go over them again. You have objection one, foundation, which in law, when you hear that objection, the attorney making objection is saying, listen, you try to get some evidence in, but you have not laid the basic information for us to rely upon it, for us to lean upon it, for us to stand upon it, to believe that it is true. Secondly, relevance. When you hear an objection to relevance, the person making the objection is saying that what you're talking about ain't got nothing to do with the ultimate question of whether or not this person is guilty, not guilty, or if they are liable or not liable if you were in civil court. And then the last objection is hearsay. Hearsay, which is where an attorney is making an objection and saying, look, there is no objection to what is, there is no, let me get my thoughts right. There is no exception that allows this out of court statement to be offered in court and to be believed on by someone, here's another point, by someone who cannot come to court. That's what you also need to know about hearsay. With hearsay, it only can be argued it's hearsay if the person who made the statement is unavailable to be in court. So again, in a situation where the gospel artist is talking to who he believes in his dad, is his dad. And his dad, as he is dying, says, you are my son, your mama told me. And the gospel artist goes to court and tries to allege that this person is his father. Well, hearsay is taking what was said in dying or death to offer it as truth, and to offer it because the dad who has died is no longer available to come to court himself to testify. Okay, so that is the third objection that I want to raise with you. Now, here's where we talk about making objections in real life. We already talked about making objections in law, making objections in real life. This is still Freedom Fridays. So my question to you is, in order to maintain or acquire your freedom, what objections do you have to make? In order to acquire and attain your freedom in this life, what objections do you have to make? What are some things that you have to question? What are some things that you have to protest because the information that is being provided or given does not suit you? It has yet to be proven. It has yet to be relied upon. So let's talk about foundation. When we are having conversations or when we are in social media, particularly because my timeline, I don't know about yours, but it's been on fire, my news feed. When we are talking about who says what, and when something is being offered for evidence, try to vet it and make sure that before you rely upon it, you have the questions asked and the answers given that talk about the who, what, when, where, why, and how. In short, know your audience. Sometimes what we share, sometimes what we believe, sometimes what we support, we may support them unequivocally, but we have not established a sure foundation upon which to rely. And so what ends up happening is the foundation is very attractive. It looks relied upon where such and such says it. So I must believe it, and that settles it. And then what happens is that your belief system, your ethos, your pedagogy, whatever it is built upon a shaky foundation. Okay, so when you are taking in information, when you are trying to engage in an understanding about something or someone, this can apply to any area of your life if you want to remain free. Do the due diligence and make sure that the foundation is secure and it has been laid. Secondly, when we're talking about relevance, sometimes someone will say something, post something, infer something, imply something, and then it is what we call in law school a red herring. So then what happens is that you're running down this lane looking to argue that, looking to put information into it, but that has nothing to do with your freedom. So every argument is not a good argument. Every conversation is not a beneficial conversation. We have to use the discernment to talk about in terms of relevance. How is this not going to just push and secure my individual freedom, but how is this freedom for the collective? How is this freedom for the community? Is it going to advance the particular needs, the particular outcomes of the community? And if it's not, then objection, relevance. Okay, we cannot always pick up an argument for the sake of picking up an argument. Secondly, after you lay the foundation, determine, is the information that I am processing, that I am repeating, that I am sharing, that I am reposting, is it relevant to the issue of liberation and freedom? Because if it's not, then you have to start asking a different series of questions. If in fact, liberation and freedom is important to you and also to the people with whom you are in community. And then lastly, when we talk about hearsay, understand, and this is to cite my dear friend and soror, Dr. Melva Sampson, the creator and curator of Pink Road Chronicles. She said in a post not too long ago that people get what are called keyboard courage. Keyboard courage, which is, I will say in cyberspace what I would never say or say the same way in your space. I'll say it again, that there are some people who have keyboard courage. Will they say in cyberspace what they would not ever say or would not say the same in your space? And so when we spread that hearsay, when we spread information from sources or places and spaces that are not reliable, that are irrelevant to what our particular purpose is, then what ends up happening is that we are now co-conspirators in the demise of people instead of trying to make sure that we all remember, that we reassess, that we reconnect with the levels of liberation and freedom that we have and the levels of liberation and freedom that we can create. Okay? So that is what I mean when I say making objections in law and making objections in real life. Process the information. Don't put your mind, don't put your heart, don't put your intuition to the side, but these are established in our lives so that we are able to think analytically, think critically, and think consistently and feel consistently before we make a decision. If there's some information or some tea that, and you know I love good tea because that's just, that's in my ancestral lineage. Don't judge me. Just because it is on the internet, that does not automatically mean it is to be believed. Just because a person says a thing does not automatically believe or mean it is a thing. Do your homework, vet it. Now, even as many times as some of you have come on Legaleaze, please, just because I said it does not make it true. Do your research. Always be wary of people who are giving you information, and then when you question them, they say, it's either you believe me or you don't. Okay? Think about things and don't just take it in for the sake of taking it in. Think critically, think, research, do your own vetting system, and then determine. Now, there are some people in some places that once it is said, once they say it, I automatically believe it. Why? Not because of who they are per se, but because of the history, because of the track record, because of their character. And I am a firm believer and witness that your character will then dictate your reputation. And if people disbelieve your reputation, you always have your character, your foundation to stand on. So these are just some ways in which you can use your objections in law and use your objections in real life. Okay. Thus concludes my presentation for today. If you wish to continue to connect with me, you may do so on YouTube. This is my Legaleaze Please channel. You can watch not just this episode. Hey, YouTube, you can not just watch this episode, but you can watch other episodes where I have talked about different topics. If you wish to support this work, understand it is not free, even though we are coming on Freedom Fridays. So there are 3 ways to support: by way of PayPal, Zelle, and Cash App. You see the different ways for PayPal and Zelle. You can email me at nlrobinson.esq@gmail.com. If you want to do Cash App, it's $Legaleaze, please. Okay. And then what happens is that you were just saying, as we say in church, a good God bless you, where you are believing in the work of a Black woman, believing in the work of an entrepreneur, and you are believing in the lessons that are being provided to you and to the community, because that's ultimately what Legaleaze Please is for, is building us up by breaking it down. Not just a terminology, but also all of the phases of oppression that prevent you and try to regulate how you receive information. We don't do that here. We are for the advancement of freedom and liberation. So that is all that I have for today. Again, if you are coming in live or if you are coming in later, please click like and share so that there are others that may not be here or others that may not know that this work exists. You can share this with them so that not only are you a student, but you are also invested as a teacher and ultimately a lifelong learner. Thank you so much for your time. Have a phenomenal week and be blessed. See you next time.